So I'm going to talk about fiduciary duties under the trusteeship theory and how how Canadian case law in judicial review of environmental matters could help, in my opinion, define what could be those fiduciary duties. So I'm going to first talk about trusteeship, but I'm going to talk about this very quickly because I think most of you know what this theory is about, and I'm going to quickly remind what are the traditional fiduciary duties under the trust mechanism. And then I'm going to talk about why, in my opinion, it's relevant to transition towards ecological law and why it's relevant in the Canadian context, and finally present some examples of the case law that could be useful for us. So this idea of imposing fiduciary duties to the state is not a new one, and it's been maybe more popular after Joseph Sachs' article published in 1970, The Public Trust Doctrine in Natural Resource Law, Effective Judicial Intervention. And in this article, Sachs was calling for more court intervention to manage and try to force governments to apply regulation and be more protective of the environment. Sadly, the public trust doctrine, as it's applied now in the US and not applied at all in Canada, has not been or has not proved so effective for different reasons. One of those, I believe, are the fact that it's really rooted on the traditional concept of property, so that the state can only protect public land traditionally close to water. So the interventions are very limited in that sense. And also because it's under states' jurisdiction, so that some states are a lot more protective than other states. And it's not consistent throughout the United States. Also, even some states have created exceptions where the state can sell the land to public interests, so that to private interests, so that it's not very protective. But after the 70s, other theories were created, like stewardship, guardianship, so related to this idea of trusteeship. One of the recent publications about that is Klaus Bosselmann's book, published in 2015, so Earth Governance, Trusteeship for the Global Common. So Global Commons, so where Bosselmann suggests how or what modification we should maybe put in place for international governance institution, so that we could maybe set up a trusteeship model of governance at the international level. And what I think is interesting about this trusteeship theory, and especially at the national level, is that it is more flexible, I believe, than the traditional public trust doctrine. It's not rooted in the traditional conception of property as much as the public trust doctrine is. And for example, under a trusteeship theory, private owners could be considered stewards of the resources on their land in the interest of other citizens and nature itself. That's an example of how it's not exactly the same as public trust doctrine. Switch. So just a quick reminder for those who are not from a common law jurisdiction maybe, or non-jurists. So traditional fiduciary duties under a trust mechanism would be duty of loyalty, so obligation to act solely for the benefit of the beneficiary, to perform personally, to invest the trust assets, to act impartially, to account, and to provide information. In a trusteeship model of government or governance, that would mean, for example, duty of loyalty could be interpreted as acting for future generations as the beneficiaries of the trusteeship model or the environment itself. Duty to invest could mean that the government would not only have to protect the environment, but also make nature thrive. Duty to account could mean more accountability mechanisms in environment, maybe sanctions to apply the accountability mechanism. So there's a lot of flexibility with this idea of fiduciary duties. So why I think it's relevant for a transition towards ecological law is that it does not only, well, Karine from the Quebec Legal Center yesterday said, under the current model, governments have only powers, but to set up a trusteeship would mean more duties and more responsibilities towards nature. And also it kind of recognizes that humans have responsibilities towards nature, so that it integrates this idea of mutually enhancing human-earth relationship. But I don't think it would be useful just like to consider the trusteeship as the solution to solve the ecological problem. I think it's one mechanism that would be interesting along with other economic change. And finally, I think it's interesting because it could be adaptive and integrative of science developing knowledge on the ecosystems. Then why in the Canadian context and why the Canadian case law? Well, we already have in our common law countries these concepts of acting in the public interest, of the government being accountable to the parliament, or the government having to be equitable to its citizens. So these concepts we already know. It would be to push them further. So I thought it would be interesting as, well, I think it's interesting because it draws on concepts we already know. Evan Fox-Descent, which is a professor here at the Faculty of Law at McGill, even suggested that the duty to act fairly and reasonably towards citizens that we already have in public law would be a translation in public law of the private duty of loyalty under the trust mechanism, so that in common law there would be an argument to say that there already exists a fiduciary obligation of the state towards its subject, which leads me to the Canadian case law in judicial review. In judicial review, courts have to review decisions to ensure that the executive representative have acted within their authority and in a reasonable manner. And when courts determine what is reasonable, they will often impose duties. And I was thinking, well, it could be interesting to see what courts have said about that and try to, of course, it's not as progressive as the trusteeship theory is because it's not in place in Canada, but still courts have been sometimes very creative in formulating these duties. So I was thinking, well, there's a lot of case law in judicial review and environment, and so it would be interesting to just try to link what is being said about duties to the actual fiduciary duties and try to define their content and substance. So that's the very small and modest goal of my thesis. And I thought I would give you a couple of examples, maybe given the time I have, I'll stick with one so we can switch. One from the Supreme Court, but if ever you're interested in hearing what I'm thinking about the two other cases, maybe we'll do that during the discussion. So I chose Imperial Oil versus Quebec Minister of the Environment of the Supreme Court. And I have to say there's not a lot of cases that have been heard at the Supreme Court that are in judicial review of the environment. So I will have to use a lot of Court of Appeals cases. But yeah, so what's interesting about the Imperial Oil, the facts are the following. So Imperial Oil operated a petroleum products depot in a city that ended in '73. And in the '80s, subsequent purchaser realized there were petroleum traces in the soil. So they consulted with the Minister of the Environment, which required further studies and finally approved the decontamination methods. But a couple of years after, the owners discovered other traces of hydrocarbons, so that they decided to file 3 actions against the city, the seller, which initially was Imperial Oil, and the minister. The city, trying to find solution to that problem, called the minister and said, well, we have to do something about it. And the minister decided to issue an order under the Environment Quality Act of Quebec, where he was asking Imperial Oil, as the former owner and operator of the depot, to perform a characterization study at its own expense, so that Imperial Oil was not very happy about that and decided to appeal of this decision from the minister in front of the Quebec Administrative Tribunal. The argument of Imperial Oil when in front of the tribunal was that the minister was in conflict of interest because it was involved in the decontamination work that was done initially, and subsequently was ordering a study of characterization. The tribunal affirmed the decision and found that the legislation was creating overlapping functions to the minister to both decontaminate and order characterization study, and so that in that case, it was an exception to the rule of impartiality and that there was no conflict of interest. The Superior Court set aside this decision, and then the Court of Appeals set aside the Superior Court decision and decided there was a state of necessity in the legislation that justified an exception to the principle of impartiality. The Supreme Court affirmed this decision, but for other reasons. And basically, what the court did is that it studied the statutory framework and to see what was the relevant role of the minister according to the legislation. And it decided that given the growing concern on part of legislatures and society about safeguarding the environment, and the fact that the minister in that case had to act in the public interest in protecting the environment and in the interest of the state to save money so that the owner would pay for the study. It was very hard for the minister to separate those interests, and in that case, the minister was only acting in the public interest and affirmed the decision. So it seems now very confusing. You have all the facts, so how is it helpful? Well, for me, it's helpful because the court was arguing about the reasonability of how the minister acted, and for me, this is interesting to interpret what the duty of loyalty is, and what this case particularly tells me is very modest, but it tells me that when the minister had to act for the public interest, even though it was at the expense of a private actor and at the expense of its own private interest, because in that case, the minister was at risk of being sued for negligence in the decontamination work. So it tells me that the public interest always takes precedence to, or in some cases where the polluter pays principle is concerned, so that the public interest takes precedence over the private interest. So this is one example, and I think, as I already said, it's modest, but if I take all the cases and it adds up, I think I will be able to try to maybe define a guideline about what could be those fiduciary duty and exercising them on a day-to-day basis for the government. So thank you for listening, and I will be happy to take your questions.
I think we have a bit of time. If you could just take maybe 5 minutes off of the wallet case.
Yeah, wallet is a bit more interesting, right?
Yeah, so you have it on your own.
Okay, so wallet was about, and as I know you know very well, the city of Quebec adopted a bylaw which was asking landowners that lived around a lake and close to the river, so riparian owners, I guess. And the bylaw was forbid them to cut trees for a certain distance from the water, and even in some cases to plant trees, I think. And the reason for that is that the city wanted to avoid a blue algae problem in the lake, and this lake in particular and the river is the main drinkable water supply in Quebec City, so that it was very important to protect. But the private owners were not very happy about that. They went to court to challenge the bylaw, and they said, well, the fact that the city wants to dictate what we have to do on this portion of land is an illegal taking. And the court reviewed all the legislation that was adopted in the years before that case in 2011. So in 2006 in Quebec, we have had, gosh, I don't know the names in English, Loi sur le développement durable, so sustainability. Yeah, thank you. And the law protecting water resources and affirming their collective. Do you know the title of this statute?
Yes, it's affirming the collective sort of the fundamental ownership of water as a communist.
Yeah, exactly. So there were a lot of statutes that had passed a couple of years before that case, which led the Court of Appeal to say that it was in the intention of the Parliament to recognize the role of government and local government to protect the environment itself. And in that case, it ruled in favor of the city and affirmed and confirmed the validity of the bylaw because it was considered necessary to protect the resource and considering the increasing role of the government in protecting the environment. But what does it tell me in terms of fiduciary duties is that still it's for the duty of loyalty that I think it's relevant, is that here it's an example of how local government can sometimes limit private rights or private property rights to protect a common resource. So that would be an example of what is the fiduciary duty of loyalty.
That was actually very interesting. Yes.
Well, it reminds me of a situation in the United States and how public nuisance has evolved, so that 100 or so years ago, it was considered a public nuisance in many courts to keep a wetland on your property because it attracted bugs. It was assumed to be putrid and bad. But there was a takings case in Rhode Island where a private property owner was not allowed to destroy a wetland on their property. And it was found there that the public nuisance law had been established when it was long enough ago, and it evolved to the point where destroying a wetland was a public nuisance because it removed those ecosystem, the benefits, the ecosystem benefits of that, that was not a taking of the property. So it's a nice kind of parallel to that case.
I have a question. So is one of your goals, perhaps through the research, to identify new ways to force governments to do the right thing for the environment by using these arguments? I guess that's the point. Not that there's not other points, but
yeah,
I would see the huge value in that.
It's really solution oriented as a research, I guess. And the thing is, there's a lot of work about trusteeship, especially at the international level. And as I said, there's work on public trust doctrine, but the way it's done, it's not exactly enough. So I was thinking, well, trusteeship theory is interesting, but we don't exactly know how to apply it. And I think it cannot be so appealing to courts to apply it in Canada and to public decision makers and the public sector to try to implement something they don't know exactly how it works.
Yeah, same in Australia. So that's why I'm interested in this. It's very interesting.
Thank you.
I shall read your final thesis for sure.
So I think, one more small.
I have one more big question. No, that's all right. That's a big question. Short, though.
I can answer short.
Short.
Go.
Let's do it.
He's a
Is
lawyer.
this way a question I've asked my friend Evan Fox Decent, who's been thinking about this as well. Because it's all about producing incremental shifts in the overall functioning of the law. We don't have time for this. So how do we shift the fiduciary context to the times and scale that we now have?
Because your question is, we don't have time for transition. We should change, like apply major changes in a short period of time. That's what you're saying, right?
I'm saying that if we implemented what you're talking about over a period of decades and more, we might move towards something, but we don't have time.
Well, I think, yeah, I agree with you. I think, but the problem is law is not the only solution to the environmental crisis, right? I think law is maybe a way of nudging and a way of implementing what science has found about how do we protect the ecosystems. But I feel that if we're to try to make change and try to transition to ecological law, we have to think about quick paradigm shift legally, but that are respectful of what is done by science. So I think the trusteeship mechanism is interesting because it could be very quick. It's based on things that we already know. So basically it would be to define, like try to have a statute with clear fiduciary duties and ways to apply them, and ask the government to ask towards it. There's a lot of other institutional changes that are suggested at the international level, but I know that at the national level, it does not require that much work. So I think that's why it's interesting.
And also, you know, before the revolution finally happens, it might help us stop the destruction of something. So, you know, you've got to do all at once. I'm on the revolution side.
I want to give you one example that my research center 15 years ago in the old NDP government got a contract with DATE, which we did. It's called the Community Ecosystem Trust. And the idea was, how could you address Aboriginal land issues by taking the federal government and an Aboriginal, an Indigenous group, and put them together and say, forget fighting over title. You got title, I got title, whoever's got title. Let's put it into a trust that talks about how not just very limited transition, but massive transition of powers from the provincial government into a trust where, you know, regulatory powers and all sorts of powers work in that area, and do it in a way that allows a transition from sort of dependence upon the state to regulate, and facilitates transition of powers of sort of different forms of regulatory power to the local level. And so I think it can be really fast, what you're saying.
Yeah.
And it could be one, you need a state to go along with it, which is, you know, kind of a problem.
But the thing is, another thing that I find interesting about this is that because the public trust doctrine is not applied in Canada, courts have already shown interest, but they kind of are trying to find teeth to apply it. So I feel if we produce doctrine that says, well, here's how it could be applied in Canada, given what courts have already done, could be interesting for the fiduciary to say, well, we'll use our common law powers and try to impose fiduciary duties. So it could be quite quick, maybe not enough considering there are other changes that have to happen, but I think it could be quite quick.
What was interesting in law and also was that talking about scientific information, that the city was in a bind because its water system was being polluted because people were building all the stuff that was being put on lawns was contaminating the water. And they had a whole crew of scientists and specialists determining exactly what had to be done to save the water. So it was you had the scientific information telling the city what to do, and the property owner is saying, but you can't do that. We own this property and you're expropriating us and we want to be indemnified.
Did they have to drink the water?
Pardon?
Did they have to drink the water?
I think
They were upstream.
they all had wells. We all had wells. So
There's the problem.
they were polluting Quebec City's water.
We should
Pardon me?
we need to move on.
Yeah, I think we have to go to the
We're
next.
done, aren't we?
Good idea, but obviously.
We're done.
My observation would be that it seems to me the public trust doctrine, following from Joe Sachs' argument, is permeated through many states in different ways, is a metaphor rather than, or a legal metaphor. And so it's really to be distinguished from what your goal is, because it's not, it does not carry with it the apparatus of the common law of fiduciary duty. Let Hillary tell me I'm wrong about that.
No, true. There are several examples of the trust concept, and we can talk about this after, but I was thinking in the indigenous context in the United States, and a terrible failure. But I think that's for some discrete reason.
I'll be glad.